Welcome to this very special Taxsutra Hangout. How often do we see the Supreme Court constitute a 9-judge bench to hear any matter? Even while hearing the validity of the NJAC, that time Supreme Court did not fall into the temptation, resisted the arguments of the Attorney General to constitute a larger bench, but not so in the case of entry tax. Venkat sir tells us it may probably be only the second or third time that a tax case is witnessing a 9-judge bench here. And the last time he tells us was Mafatlal. That's what he tells us. But what a case awaits us. History beckons us a month from now when the Supreme Court 9-judges bench hears the challenge to the entry tax by so many corporates. 6 years back, Chief Justice, earlier Chief Justice of the Supreme Court, S.H. Kapadia, sitting in a 5-judge bench, that 5-judge bench referred this entry tax conundrum to a larger bench, an appropriate bench, 7 or 9, and therefore this 9-judges bench has been constituted. They will be deciding several questions of law, substantial, important, big questions of law. One, does entry tax violate Article 301 of the Constitution, that is free trade and commerce? Does the entry tax meet the compensatory, the test of the tax being compensatory in nature laid down by Article 304? Is the word "and" appearing in Article 304? Is it conjunctive or disjunctive? Oh, I'm sure PVS is smiling. These are questions that we are going to hear from the Supreme Court. But I'm joined by my colleague Aditya, and I would request him to give a judicial, the judicial history of this case. It has a 49-year-old history, and I request Aditya to take us quickly through the history. And later, we have 4 top tax experts: Senior Advocate N. Venkatraman from Chennai, Mr. P.V. Srinivasan from Bangalore, Pramod Jain, tax head of Flipkart, and of course, legal Rohan Shah of ELP is also with us. Thanks so much, everyone, for joining us. Aditya?
Yeah. So, the whole challenge began with, the 5-member bench Supreme Court judgment in Atiyabari Tea Company Limited, where in 1960 it was held, where the Assam Taxation on Goods Carried by Roads and Inland Waterways Act was challenged as being violative of Article 301, and it was because it was challenged on the ground that it was not passed after obtaining the presidential sanction, which is envisaged under Article 304. The Supreme Court at that time struck down the law, saying that the tax vested by legislative list in the Parliament or state legislature is subject to Part 13 of Constitution, which is Article 301 and all that. And that is why if they do not conform to the requirements of that particular part, then it is invalid. Then it moved on to there was another a 7-member judge bench, 7-judge bench before in the case of Automobile Transport Rajasthan Limited versus State of Rajasthan, where the Rajasthan Motor Vehicles Taxation Act was challenged. And there they said that it was held that the regulatory measures or measures imposing compensatory taxes for the use of trading facilities do not hamper trade, commerce, or intercourse. Rather, it facilitates them, and therefore will not hit by the freedom declared by Article 301.
Absolutely. Yeah. So this judgment holds forth. Yeah. And then you have another few cases. You had a slew of High Court decisions which were contradictory. Correct. It went up to the Supreme Court, and therefore the bench led by Justice Kapadia, I think, referred this to a larger bench. Fascinating history. If I could take the viewers through some of the questions that the Chief Justice Kapadia bench referred for a larger bench. Interrelationship between 304A and 304B articles. The significance of the word "and" between Articles 304A and 304B. The significance of the non-obstante clause in Article 304. The balance of freedom of trade and commerce in Article 301. Vis-a-vis the state's authority to levy taxes under Article 245 and 246 of the Constitution. I think this is one of the most significant aspects. Venkat sir, if we could start with you and then move to Rohan bhai.
Before we get into the 9 bench, we need to know a few steps forward and the background. So 3-4 principles are very important before we understand why 9 judges are going to decide this matter. First point is, in Atiyabari, for the first time, Supreme Court said tax can be read as a restriction to freedom of trade under Article 301. That was the first question. When you read freedom and restrictions, does it include tax? Achebari said you should read that limitation first. That's the first principle. Now the second principle got evolved in this Automobile Transport Corporation, wherein because Article 301 was read to be regulatory, can you therefore collect money and demonstrate that it is compensatory in nature and therefore justified? See, our Part 13 is a hybrid of both the American Constitution and the Australian Constitution. It combines the commerce clause of America and the regulatory clause of Australia. So you have both the compulsions blended together in our Constitution. That's the beauty of our Part 13. So this compensatory tax was something which was a judicially evolved concept. And they said two things about it. A, if you collect money under a regulation and as a regulatory practice, you are justified to do so. But they laid down a very important caution test. They said there must be a direct and proximate nexus. That's the test laid down in automobile. That was holding the fort till 1995. Then came Bhagat Ram. Bhagat Ram diluted automobile test and said that you don't have to have a direct and proximate link. Even remote indirect nexus is sufficient to say something is compensatory in nature. And because of this divergence, Jindal had to take a call whether Bhagat Ram is right or automobile is right. And Jindal finally said that automobile test is the right test. It can be compensatory, but the text has to be a proximate and direct test. And now, after that, this reference to 9 judges came. Why? Basically, this is the first part. The second part you must understand is Part 13 has 4 articles, 301 to 304.
Yeah.
You can put the entire conspectus in 5 bullet points. The 5 main bullet points of Part 13 are: 1. Article 301 says, as far as trade and commerce is concerned, there are no state boundaries. It is boundaryless. India is one homogeneous whole.
Yeah.
Article 302 says it permits the parliament to impose restrictions if provided they prove that there is a public interest. Article 303, that's the third test, which says it dissuades both the parliament and the states to impose any tax which is either discriminatory or does not have the substance. 4. Article 304 permits every state to impose a tax at the stage of entry, provided it is not discriminatory in nature. And 5. 304B permits restrictions and regulations to be in place, provided it has the assent of the president.
Yeah.
These are the 5 bullet points of Part 13.
So I'll just bring Rohan Bhai here, and I'll come back to you on that. Rohan Bhai, fascinating, interplay. How do you juxtapose 301 versus 304?
Yeah, so Arun, what you will have to see is that in the scheme of the Constitution, 304 is a non-obstante provision. So it operates notwithstanding the scheme of 301 to 303. And to the extent that it is non-obstante, somebody will effectively take up the point that as far as this is concerned, this operates, deholds whatever be your scheme of 301 to 303. Now, under 304, and let us just look purely at 304, because if you see the questions as framed, the very first question that the Supreme Court has framed is solely qua 304. How should you read it? And as you said, the first situation is it to be read cumulatively, namely that you must satisfy both the ingredients of 304A as well as 304B simultaneously, and only a cumulative satisfaction allows you to meet the test of 304. But even if we were to see these two separately, 304A basically talks of what is a non-discriminatory levy, and in most people's common perception that would mean a countervailing duty. Or it is a duty which is ultimately restorative to bring about a parity between what is happening domestically and goods which are effectively entering. If you see B talks of a restriction, but as has been said, in the course of interpretation, one interpretation is that if A covers tax and therefore the domain or the field of A is defined, then restriction under B cannot again cover a tax, and B therefore must be seen as being distinct. Now, if I understand the approach that the learned senior counsel who is going to lead this is going to take, then his situation is going to be A, very likely that 304A doesn't apply to the nature of this levy, it is not countervailing. 304B also doesn't apply, because this is now you're talking of a restriction distinct from a levy of tax. Both of these in their own sphere don't apply, and in any case, therefore, cumulatively, they cannot be said to apply. So when you talk of 304, A, it is dehors the scheme of 301 to 303. It has the A and B. And I think the arguments will be that individually also A and B don't apply. And certainly if the test is cumulative, then that also certainly doesn't apply.
Yeah. So, Pramod, can I get, before I get to previous, can I get what's the industry impact? Flipkart has challenged the entry tax being imposed on online companies like you. You have challenged it in several states. What is your rationale, Pramod? Does it somewhere fit into what Rohan Bhai and Venkat sir just said?
Yeah, so our rationale basically is that this tax, entry tax, which is being imposed in more than 6 states, and which has become a more recent phenomenon in the last 3-4 months, is more discriminatory and it's anti-consumer in nature. So if you look at the nature, how the e-commerce industry operates, the industry facilitates B2C sales. So which basically means that CST is already paid on the transactions before the goods reach the customer. Now, because of the interstate rivalry, or the consumption state feels that they are not getting the appropriate tax revenue, they have been going after and imposing taxes on in the name of entry tax. So this entry tax which is being imposed is neither compensatory in nature, nor it is in the public interest, and nor there is a presidential assent to that. So that's primarily the basis on which we have gone about challenging this tax in multiple states across the country. Although as the legislation is also pretty new, and some of these concepts around B2C transactions have not been tested in the previous cases which were decided by several high courts. So most of the high courts have upheld the levy of entry tax on the basis that it's compensatory and there is a set-off being provided under the local VAT. So a concept of the goods entering a state after suffering CST, that has not been tested, and it will be probably tested now.
So,
when
Pramod, is it fair to say that your case is on a different footing from what's being heard here?
Yes.
Yeah.
More on a discriminatory aspect, where CST has already been paid. So in addition to the limbs of 301, 304, the limb of Article 286 also is there, which provides that if a transaction has already suffered CST, it's in the course of interstate trade, then the states are not empowered to levy any further taxes on that.
So I'll come to PVS sir, then Rohan Bhai, and back to Venkat sir. PVS sir, Aditya has a question for you.
So, just for the interest of the readers and others, if you can explain what this compensatory tax is and what is the concept of compensatory tax, and vis-a-vis the entry tax which is being levied, because when we say that we're talking about compensatory tax, we're talking about providing certain facilities for trade, and for which this is a sort of a fee probably that they are collecting. So if you can elaborate on that.
So the correlation of compensatory nature, it is difficult to correlate because neither the state government keeps a record of what is the nature of facility it has provided, nor the taxpayer has got any some kind of an access to the data as to what kind of facilities have been provided. But that is not the grievance, if I may say, because finally what kind of facility is provided can always be put across by any state. They are all available to every public, every enterprise which is doing business in the state. Possibly these are made available to the person who is bringing goods also into the state. So I have no difficulty in accepting that if it's compensatory, the state will be able to establish what is the compensatory nature. My difficulty with entry tax comes only because, number one, it is not a levy at the point of entry. is the levy which happens subsequently. That means it is to be discharged at a later point in time, determining by the businesses will have to determine which nature of goods have entered the state, whether that particular nature of goods is liable to entry tax, and therefore ascertain and determine the liability and pay it. So I would say it's an administrative issue which is difficult, and therefore it is causing a little amount of problems for most of the industry players here. If all the goods are liable to entry tax, then possibly it becomes easier. But some goods are liable to entry tax and some goods are not liable to entry tax. It makes the challenges of segregation a little amount of challenge, certainly a challenge for most of us, if I may say. So once it is established that it is compensatory, then I think the levy will be sustainable. Then I would request the administrators to make it easy for compliance. At what point it should be discharged can be one method of determining.
Sir, Venkat sir, before I get to Rohan Bhai, I would like to read what the Supreme Court said while referring this matter to a larger bench. This is the Justice Kapadia bench. They said that in Keshav Mills versus CIT, the Constitution bench of this court enacted the circumstances in which a reference to larger bench would lie. It was held that in revisiting and revising its earlier decision, this court should ask itself whether
justifiable
the interest of the public good or for any other valid and other compulsive reasons, it is necessary that the earlier decision should be revised. So the court was very mindful in the circumstances under which this was referred. It's quite rare, sir, that a 7-judge bench decision is being referred to a 9. So very clearly, the Supreme Court itself, the 5-judge bench had doubts over the correctness of the 7-judge decisions.
See, Arun, there are 3-4. In fact, I'll take it from where Rohan and Pramod left, because there are, and even previous. Each one has a point to say, which I'll bundle, because these are the 3 main issues which may come up for consideration before the Supreme Court, and they have put very nice questions for contemplation. The first principal question we have to understand is: state under the Constitution has independent legislative power to tax.
Yes.
So, how do you read Part 13? Can Part 13 overrule state legislative power, or it should be read harmoniously, or can it have overruled? This is the first principal question between, you have to balance Part 13 and Part 11. That's the first challenge you have. Now the second challenge is, see, there is a dividing line between a compensatory tax and a tax. And Jindal has made that point visibly clear.
So that
divides a beautiful example. Suppose there is a pipeline running through. There is a pipeline running. Hello, can you hear me?
Yes, sir. Please go ahead.
Hello. Yeah. Now there is a pipeline running for. If you charge, see, from Gujarat to Allahabad via Madhya Pradesh, if Madhya Pradesh is going to charge a fee, so that its pipeline, or because it is running through its states, then it is compensatory in nature. Whereas if Madhya Pradesh is going to impose a tax which will restrict free flow of goods through Madhya Pradesh to Allahabad, they have said it is not a compensatory, it is actually a regular tax, and therefore it has to survive the test of Part 13. So compensatory tax is not a burden or a tax. That's the principal distinction we must understand. That's the second question. Now the third question, according to me, what Rohan Bhai, it's a good perspective, but there might be, we may have to work a little more on that. When Supreme Court has said you have to read tax as a restriction in 301, can you diverse it out of 304? That's the point. So, in my opinion, it will be advantageous to argue that it's a restriction rather than to abandon it. Once you argue it's a restriction, you can get over compensatory levy so that the burden will be on the states to show that in all these taxes, we are not fighting on compensation, we are actually fighting a proper valid entry tax. That's exactly the challenge which me and Pramod are now doing in 6 items.
Yeah.
In all these new legislations, they have abandoned the theory of compensation. They know that it won't survive. They are all quite aggressively imposing an entry tax, which Rahul Bhai was saying, thinking it is to be countervailing, but in reality it is not countervailing. When you actually take the cost, the goods which flow outside the state into state cost more than the goods which you procure within the state. We have
Perfect.
demonstrated it in all the high courts.
Yeah, yeah.
That's the challenge. These are the three major key points which this 9 judge will be able to take a call. Go ahead.
Rohan bhai, you want to address any of those points? Yeah, Rohan bhai.
Sorry?
Rohan bhai, I wonder which of those three are going to be the most determining question, or we could take a few more. If you look at the questions framed by the Supreme Court, Rohan bhai, there is one point which has come out: the word "and." Whether the word "and" is conjunctive or disjunctive. How would you read that, Rohan bhai?
So the
In Article
situation here again is coming down to your interpretation of 304. And when you talk of whether it is conjunctive and therefore cumulative, your ultimate test is going to be whether both parts, that is A and B, are capable of being simultaneously satisfied. And therefore, you will have to articulate a series of examples in which you can say that both of these are capable of simultaneously being satisfied. Absent that simultaneous satisfaction, you will not be able to read it in the context of saying it is conjunctive, because we have a series of judgments, various judgments of Justice Hidayatullah, etc., which have said that whether this is an and or a or will always depend upon the contextual interpretation. But the one way to look at it is, if we look, they've consciously used the word and. We can't effectively overlook that. The question now is that if we interpret it as an and a conjunctive, then are there situations in which this conjunctive interpretation is capable of factually bearing fruit? If that is something which is possible, then they will probably lean towards the issue of it being conjunctive. So again, it will be for industry and those arguing on behalf of industry, including ourselves, to really show the situations where you can actually give this a conjunctive impact in terms of the factual profile you have. Let me just take also a minute in terms of the compensatory. We have seen in the recent past where 5 judges have sat, 9 judges have sat, while we as assessees and while we as people who have an intrinsic interest in the evolution of the law would like the courts to answer each of the questions as framed. We have been seeing, whether it is the Otis case, whether it is the other cases, that oftentimes the court really decides one core issue and then says that we will return this either to the high courts or to the tribunals to now decide this in different fact patterns. What I am hoping here is that, now that we have the rare occasion of having a bench of 9, that several of these issues are dealt with, and I am also hoping that the specific issue of compensatory is also dealt with. Because, while I've heard one of the other panelists say that, look, there can be some sort of a broad correlation, I do believe that what you effectively had in terms of the direct and proximate test is what you need more so in an era where government collection and government expenditure are increasingly coming under scrutiny. You cannot have an opaque system in terms of which you say, I generally collect and I generally spend. And if I generally collect and I generally spend, then that is sufficient in terms of the compensatory character principle.
Yeah, Rohan bhai, what happens when GST comes in? Let's assume GST is passed. Does this question then become irrelevant, Rohan bhai? And then I'll go to Pramod on this.
From my sort of perspective, when you talk of a GST which will sort of subsume all of these indirect taxes other than the ones that are specifically out, and where you have the concept of the CGST and the SGST, obviously this sort of issue will come about lesser, because even if you see the GST in the manner in which it seeks to impact Article 246, the general rule of primacy secured to the center is in a way almost being reversed. So from my perspective, in the context of the GST, some of these issues certainly should abate, but it again depends upon the manner and structure in which you will eventually write your GST law, because ultimately you are now sort of writing something to actually subsume all of this and hopefully extinguish all of these challenges.
Yeah, Pramod, where does e-commerce industry fit in the entire GST and entry tax scenario?
So the hope and wish, Arun, is that
once GST is in, then this entry tax becomes irrelevant, and the states do not go after implementing a tax by a different name. So that's the hope also, and that's the wish also. So again, time will tell how true these things will come out. We had different experiments when we migrated from sales tax to VAT also. Similar things might happen in GST. But again, the good thing, so again, talking more specific on the e-commerce. So when we say see the real reason behind imposition of this entry tax on e-commerce specifically, if we talk about states like Uttarakhand, the Gujarat, Rajasthan, Bihar and all, very clearly they are making out a case that the states are losing out revenue because the goods are being shipped from other states. And there is some kind of discomfort with the local dealers also. So the states are inclined towards giving protection to the local dealers from losing their business. So it's both protectionist in the nature and also from the imposition point of view in the nature of collecting more revenue.
Doesn't Pramod,
We are hoping that
Pramod, isn't one of the objectives also to ensure that all these state governments get their pie of the online marketplace? Everyone wants a pie of the revenue, probably, and they feel they're not getting taxed anywhere. Therefore, one state government started. Now several are imposing. You saw UP impose a 5% tax on e-commerce last week.
Yeah. So the Arun, the more relevant point is so yes, e-commerce industry, we are happy to pay taxes. It's not that the case is for avoidance of taxes or evasion of taxes, but the tax should be imposed and collected only in one state and not in multiple states. So what is happening today, you have to pay state tax in the origin state also because it's a predetermined sale, and then the consumption state also wants to collect tax in the name of that the consumption is happening in our state. So it straight away goes into against the concepts of CST Act also and the Constitution also. So that's where this entire controversy or interstate rivalry is coming into play, and which more than the industry I would say is hurting the consumers, because ultimately consumers end up paying more taxes.
Previously, if we can, take down a couple more questions, I'll come to all the panelists. So one of the questions referred to the larger bench is whether the word restriction in Article 304B includes tax laws, which Venkat sir referred to. Next is very interesting. They ask the question: is taxation justiciable? And whether the working test laid down in Atiyabari makes a tax law per se violative of Article 301. So your take.
You want me to answer a constitutional question? I'm happy when there's other constitutional experts sitting on the panel. What I will possibly comment is that any tax is certainly a restriction. I think there is no difficulty in accepting that is a restriction. But if it is levied with the authority of law, that restriction is acceptable. If it is levied without the authority of law, that restriction is not acceptable. That is where the distinction I would like to make. As far as entry tax is concerned, where is it figuring? You want to levy it as a tax, you have got the enablement, you can do it, subject to the conditions of 301 to 304, if I were put it all put together. In my view, the test of 304, as the senior counsel made it, is that whether it is a compensatory tax, and if it is a compensatory tax, do you have measures to know whether it's compensatory, in what manner it's compensatory? Why would you choose certain goods for levy of entry tax while you will leave out other goods when it is in the nature of compensatory? All these issues would be the one which possibly will bring out some highlight to the code that it is not actually a compensatory tax, but it's actually a tax which is being collected to gather revenues, and its application is left to the state. It may apply on any cost which is not related to trade commerce also.
Giri?
Yeah, Venkat sir, Aditya wants to ask a question to you.
Yeah, go ahead.
I just want to know that if, in case the 9-judge constitution bench, they do strike the levy down, what happens to the entry tax that has been collected, and what the next step forward? What happens after that?
No, they have done this earlier in synthetic chemicals, where they have said, assuming it is, Supreme Court has a natural power called doctrine of prospective overruling. That's the only court which is empowered with this natural power. So in synthetic chemicals, this is what they held. They held the levy to be bad, but declared wherever assessees have already paid the taxes, it shall not be refunded. Wherever the assessee has not paid the taxes, he need not pay. So they will secure that interest, But see, what should be the goalpost? What will it finally reduce to? According to me, two things are likely to happen, sir, in this large debate. There will be, we should pursue the path of holding the view compensatory is always only in the realm of regulation and administration. It can't come into tax. And there is enough seed already sown in various judgments rendered so far. They have issued a clear guideline. If you want to pursue the path of compensatory, then the revenue has a limited chance of only staying and proving it is regulatory in nature. Now, once they abandon that ship, then they are left to defend it in terms of Article 304A. You can read it disjunctively, you can read it conjunctively, I have no problem. You can read and or in whatever way you want. It can't be discriminatory, it can only be countervailing in nature. If you are imposing a tax, it can only be countervailing. That's exactly what we are arguing. For example, in Uttarakhand, what Flipkart, we are arguing in Flipkart is, on the click of a button, you order a phone, it is liable to entry tax from Delhi. Sitting in Nainital, you don't order it over the net, you write a postcard and order one phone. Two phones travel from Delhi. The phone which travels against a postcard does not suffer entry tax. The phone which travels against an internet booking suffers an, it can't be more absurd. It can't be more absurd. How will they justify it?
Yeah.
In Bihar and Gujarat, they are imposing an entry tax but not allowing a consumption credit. So that 4% or 8% or 6%, whatever you are levying, adds to the ultimate consumer's pocket.
Yeah.
So what will happen? A consumer in Bihar, in Patna, is dissuaded from purchasing from an electronic purchase. He has to rush to a nearest dealer to procure it because it is 6% more.
So clearly, sir, you are arguing it's discriminatory. I'll have a final word from all the panelists. One by one, last question for you. Let's assume that the GST is not passed. Let's assume the worst case scenario, and the entry tax is struck down. That's the best case scenario for you all. In that case, what happens to the coffers of the state governments? What new tax can they think of which is compensatory in nature, which will meet that compensatory test of owned by? I mean, surely the coffers cannot go dry, right?
So it's a good thing to have a state perspective to say what can fill my coffers, but essentially what is going to sort of play out in the context of what's in the Supreme Court is that all powers of state will get tested on the anvil of constitutionality, the constitutional empowerment, the issues of discrimination or arbitrariness. So what you are sort of going to see here is, and this is really my hope in the context of this judgment, is that I do hope that the Supreme Court does take up all of the issues, because many of them are critical, not only in the context of entry tax, but in terms of so many challenges in indirect tax which are today currently surviving. Maybe many of them will not survive in the context of GST, but this whole generation of litigation which will precede GST also has to be finalized. So from my perspective, the situation is, what can state do? Well, the one very clear situation is state can't do what is constitutionally unsustainable. Second, what is it that state will come up with more so in terms of what we've heard from Pramod and senior counsel? Yes, you have a completely new commercial realm in terms of the internet, and laws will need to sort of evolve to not only capture that, but to be equable and equitable in terms of how you tax that. But the last issue, which is the issue in terms of 301, 304 and the compensatory character, I think these are the two basic issues which will come up before the Supreme Court. And I do hope that they don't stop at the 301, 304. I do hope that they will also travel to the realm of what is the compensatory character, because that is again an important aspect of the law which has evolved, and everybody is looking at the Supreme Court in terms of how they do it. Like I said, their judgment needs to offer us the guidance, because opacity on this concept is certainly not what can sustain taxation, whether in the past or in the future.
Yeah, thanks so much, Rohan bhai. Final words from PVS sir and Pramod. PVS sir.
No, I'm just eagerly looking forward to what the Supreme Court will do. I think the three aspects which was laid out earlier, I think those are the essential ones. And I'm very clear that the way trade and commerce is progressing using technology, this is a very important decision for all of us. For example, whether you do the transaction on e-commerce or otherwise, whether there should be a tax based on the mode of delivery or the mode of ordering, I think this will become a very important decision for the industry. I think that is the important. Otherwise, entry tax was not even discussed earlier. Now that e-commerce has come in, and almost every state is embarking on levying an entry tax for e-commerce transactions, this assumes a special importance at this point in time.
Pramod, you plan to intervene in the Supreme Court case? Pramod? Yeah, I think.
Arun, I may even add that already the exporting states are causing some amount of upset by dissolving the input tax, and now the importing states are causing another difficulty by putting an entry tax. So you have got two levels of difficulty: the exporting tax trying to restrict the amount of credit, and the importing tax trying to levy an entry tax. So it looks as if the goods will have to bear a higher burden of tax.
Yeah, I think, of course, which means the citizens have to pay more. Pramod, last word from you. Are you planning to intervene in the Supreme Court case, Pramod? Is Flipkart planning to file an intervention application?
So we are still evaluating the strategy, and actually we do not have any High Court judgments right now to directly appeal to the Supreme Court. So certainly the effect of intervention is under evaluation.
Yeah.
And decide in due course.
Yeah.
I have 30 seconds.
Yeah, we have exactly 15 seconds left. Venkat, last word. 15 seconds.
Two levies are now threatening here. One is the entry tax as far as indirect tax is concerned, and another is the equalization levy for direct taxes. At this moment, according to me, both are unconstitutional. We have justifiable grounds to defend so. Bye.
Rohan bhai, we'll sign off with you. 5 seconds.
Interesting point in terms of the equalization levy also, but I would like to sort of ensure that this whole debate is only centric to the e-commerce industry.
Yeah.
Obviously, historically, we have a lot of people impacted, and I think if we get the history right, then hopefully we have the right compass in terms of how to, look at the technology of the future and the transactions of the future.
Thanks so much on that note. Thanks so much, Rohan bhai, Pramod, PVS, Venkat and my colleague for bringing in the judicial 49-year-old history of this entry tax case. It's really going to be fascinating. The 9-judge bench. We are going to be there in Supreme Court on July 18th to cover this case, and we will bring you the action blow by blow, what transpires in the court. In the meantime, we also wait for the constitution of the bench. We need to see who those 9 judges are. Thanks so much, everyone.
Thank you.